Officer Doherty's search of the defendant's car.
And could you identify yourself one more time?
My name is Sriram Padavatan.
Thank you. Proceed.
The items in question were witnessed under the plain view exception, and the officer's search did not intrude upon any form of the defendant's expectation of privacy. Officer Doherty's expertise in drug recognition and prior conversations with the defendant about drugs led the officer to believe that the items were incriminating. The officer's second position, partly over the hood, was a vantage point that simply allowed Officer Doherty a plain view of the interior of the vehicle.
Okay, so the officer's actions to move gave him a better view inside of the vehicle, right?
Yes, Your Honor.
And when you're talking about those officers' actions, did those actions include him stepping up on the tire of that vehicle?
They did.
Okay, so my question is Arizona versus Hicks, where if an officer can't move a stereo to look under it, why should an officer be able to step up onto a tire of a vehicle? Well, before we do that, let me ask you this. What do you think is more offensive, picking up a stereo and looking at the bottom of it, or stepping onto the tire of a car? What do you personally think is more offensive?
Personally, I believe that picking up a stereo is much more offensive.
Really, why?
Because he is actually moving an object. In this case, Officer Doherty was not moving anything. He was simply using his surroundings to gain a view into the car.
Okay. All right, proceed.
The prosecution asked that the evidence be admitted. The evidence witnessed by the officer is legally collected evidence under the Fourth Amendment for 3 reasons. Your Honor, the vehicle was located in a public area. In the case of United States versus Dunn, officers were able to shine light into the barn of a defendant without violating the Fourth Amendment. The officer's actions did not violate the Fourth Amendment because the barn was in an open field, just as the car was in this case. The Fourth Amendment protects the unlawful invasion of private land. However, open fields or public land is not protected. In this case, the defendant's car was in a public area. The officer was also in the same public area, and thus, Officer Doherty's search is allowable under the Fourth Amendment exception. The search was justified under the plain view exception in the Fourth Amendment. In the case of People versus Rogers, an officer shined a light into the interior of a defendant's vehicle and witnessed incriminating photos. The incriminating photos were in the officer's plain view and would have been seen as out in the open by anyone else. Because the officer had easily seen the photos, they were not protected evidence under the Fourth Amendment, and witnessing them was completely legal. This would justify Officer Doherty's similar action of shining his flashlight into the defendant's vehicle to see the items in question. Because the items were visible through the window, any other passerby could have seen them as well. They were in plain view. The search of the defendant's car was also legal because of the reasonable suspicion that the illegal drugs were present in said vehicle. In the case...
Well, let me go back for a second. I want to make sure I understand this right. You say any passerby could readily see these objects. You mean any passerby that took the time to look through a 2-inch gap in the window or to step on top of a tire to look inside of the windshield and get a better position of view in. Wouldn't you mean that?
Yes, regardless of what was done, any passerby could have done this and could have seen through the window.
Okay. All right.
In the case of Texas versus Brown, an officer witnessed a balloon fall from the hand of a defendant, and he suspected that the balloon contained narcotics. The requirement of a warrant was deemed a needless convenience by the court due to the officer's first-hand perception of incriminating evidence. In this case, Officer Doherty noticed a backpack inside of the vehicle, which he identified as the defendant's. Because of the officer's drug expertise and previous conversations with the defendant about said drugs, the backpack was perceived by the officer as incriminating. The reasonable suspicion standard in the case makes a warrant as a needless convenience, Your Honor, as detailed in the case Texas versus Brown. Your Honor, Officer Doherty had full right to be in the parking lot that evening. Officer Doherty's actions were allowable under the limitations of the Fourth Amendment based on a plain view of the items, and the officer's first-hand discovery of incriminating evidence. Please allow this legally collected evidence to be admitted. Thank you.
Thank you.